Good afternoon, everyone, and welcome to this LexisNexis Risk Solutions webinar, Understanding the Impact of the Sapin II Law. Before we begin, just a few brief announcements. The webinar is being recorded and an on-demand link will be sent to all attendees after the webinar. For an enhanced view of our presentation, click the Enlarge Slides button located in the grey bar above the slide window. To download a PDF version of the slide presentation, just click the green folder icon located at the bottom of your console. You may ask a question at any time. To submit yours, please click on the Q&A icon at the bottom of the screen and type it into the question box area that appears, and then hit the Submit button. I will now hand over to my colleague, Kader Jouadi, to introduce our session today.
Thank you, Holly. Good afternoon, everyone. My name is Kader, and I'm responsible for the French market for LexisNexis Risk Solutions, and I'm based in Paris. So I thank you for attending the webinar today to discuss the impact of the Sapin II Law. So today on the call, we have Charles Thomas. He's the Director of Anti-bribery and Corruptions at LexisNexis Risk Solutions and has over decades of experience of working with clients on the issues of anti-bribery and corruptions, third-party risk management, and due diligence globally. And as a guest speaker, we are delighted to have Brian Sillerman from Uber and Reed. He's a partner and a senior member of the firm Anti-Corruptions and Internal Investigations Practice Group. He is currently working out of Paris, and we'll be happy to listen to both of them today. If you have any questions, please feel free to submit them in English or in French, and we'll be happy to take them. Over to you, Brian.
Great. Well, thank you very much, Kader. We'll begin with a bit of an overview of Sapin II, and then I'll hand the presentation off about halfway through to Charles. But thank you for participating, and hopefully you find this to be interesting. Please feel free to ask questions, as our presenters said. Just by way of context, it's important, I think, to point out that most of the discussion today in France around Sapin II, but prior to Sapin II, the French Criminal Code had already prosecuted corruption, both passive and active corruption, public and private corruption. But one of the main drivers of Sapin II was the view that although France had on its books laws that prohibited and prosecuted corruption, it wasn't doing enough to enforce those laws. France, like a lot of other countries, is a signatory to the OECD Convention, and as part of the OECD working group, received periodic evaluations of its compliance enforcement. And in those evaluations was considered not to be doing enough to prosecute corruption. You also had a situation where authorities in other jurisdictions, and primarily the United States, were focusing on French-based multinational companies. And Charles will point out a few examples of those, but there were several significant corruption-related prosecutions involving French companies. And the view in France was that if we are going to become more active in enforcing our anti-corruption laws, we should be doing it in a way that is more French and that is more consistent with our legal frameworks. And so discussions began around the passage of a new anti-corruption law, which eventually resulted in the passage of Sapin II, which was adopted in December of 2016. There are four primary components, and we'll talk a little bit about each of these. The first is that it created an affirmative obligation for companies of certain size to implement an anti-corruption compliance program. The second is that it created a new agency, the AFA, or the Agence Française d'Anticorruption. The third is that it removed and altered certain procedural hurdles that made it difficult to prosecute international corruption cases in France. And the fourth is that it introduced a new settlement mechanism known as the the CJIP, or the Convention Judiciaire d'Intérêt Public. I will not go through this slide in a lot of detail, but there are both similarities and differences between Sapin II and other international anti-corruption frameworks. The two most frequently cited are the U.S. Foreign Corrupt Practices Act and the UK Bribery Act, and that's because of their broad jurisdictional reaches and also because of their active enforcement. The U.S. being an older law but very actively enforced, and the UK Bribery Act having been passed in 2010 and extending to a lot of international companies, it's natural to do a comparison between Sapin II and these other frameworks. Perhaps the biggest difference with Sapin II is that, unlike the FCPA and the UK Bribery Act, Sapin II introduced an affirmative obligation for companies to adopt a compliance program. In the U.S., adoption of a compliance program can be a mitigating factor in a settlement and can result in reduced penalties and perhaps the avoidance of a monitorship. In the UK, it can be used as an affirmative defense in circumstances where companies are prosecuted for corruption. But here in France, you have a situation where companies can be sanctioned for the failure, companies and individuals can be sanctioned for the failure to adopt a compliance program consistent with the requirements of Sapin II. In terms of its applicability, the law extends to about 1,600 companies and entities at the present moment. Those are French headquartered companies with 500 employees or more around the world. It also includes branches or registered companies of non-French multinationals that have themselves 500 employees or turnover of more than 100 million euros in France. So if you have a company that is headquartered outside of France but has a substantial operations in France with more than 500 employees and turnovers of more than 100 million euros, it will fall within the scope of Sapin II. It also extends responsibility to individuals. Legal representatives for companies that are subject to the law are required to take steps to ensure that the law is appropriately implemented within their organization and to take steps to prevent and deter corruption. And importantly, sanctions can be applied against both the corporate entities that are subject to the law and their legal representatives. In terms of its requirement to affirmatively implement a compliance program, we see a good bit of similarity between the elements that are set forth in Sapin II and the elements that are described in other applicable legal frameworks, such as the Foreign Corrupt Practices Act or the UK Bribery Act. Those laws tend to describe these elements in slightly different terms. But if you look across the board, you'll see a lot of similarity in the elements that are considered to make up an effective compliance program. Here in France, the new agency that is responsible for enforcing Sapin II, the AFA, has released guidance on its website in both French and English relating to these 8 measures, and it's helpful to review that guidance and see how it considers companies should go about implementing these various mechanisms. I won't go through each of them in detail in the interest of time, but starting with the risk mapping, if you look at the guidance that the AFA has set forth, it recommends that companies engage in an assessment of both their gross risk, that is their risk of certain activities or certain operations, without taking into consideration various compliance controls, and then taking into consideration various compliance controls, assessing the net risk. And so looking at what risk exists generally, and then taking into consideration what controls or mechanisms the company already has in place in order to help mitigate those risks, to give you an end net risk. And so companies here that are subject to Sapin II have been quite actively engaging in this risk mapping exercise, in which they can better assess the areas within their operations, both geographically and operationally, that may subject them to the greatest risk of a corruption offense occurring. You have similar requirements for the adoption of a code of conduct, for the adoption of various accounting controls, which are similar to the requirements and the recommendations set out in the FCPA, in the UK Bribery Act, and you also have, perhaps not surprisingly, a good bit of focus on third-party due diligence. When we look at the anti-corruption landscape, and France is no exception, the authorities recommend that companies focus a substantial amount of their effort on assessing third-party risk. And Sapin II describes that requirement quite broadly and recommends that companies take into consideration all types of third parties with which they work, including client relationships, in order to assess the potential for corrupt or improper activities take place within those relationships. A few words on the AFA. So the AFA has two primary missions. The first is to serve as a source for advice and for assistance of both public companies and private companies that are subject to Sapin II. And as I mentioned, to develop recommendations for those entities in order to implement and adopt effective compliance programs. It also has an audit function, and we'll spend a few minutes talking on the next slide about these audits, but it is responsible for performing audits of companies that are subject to Sapin II, and for issuing reports of those audits with recommendations and, if necessary, sanctions for companies that have not adhered to the law's requirements. It's an independent agency, so the AFA sits under the authority of two agencies, the Ministry of Justice and the Ministers of Budget. And one of the reasons for that is that one of its primary mechanisms is to ensure that the responsible governmental agencies are sharing information. And so there are two agencies to which it reports to assist in its information sharing role. And the idea being that the more information that is shared within governmental agencies, the more transparency that will go into the AFA's activities, and the more effective that it will be. But it does operate independently. It has autonomous power to cover all of the French territory. It decides which companies or which entities will be subject to audit, and it currently has about 60 employees working for the agency. There are plans to add an additional 10 or so, from what we have heard, to bring the total number of staff up to around 70. And it has fairly ambitious goals. It's led by an individual named Charles Duchesne, who is fairly outspoken as to his desire to make the agency a real leader in the enforcement of Sapin II. And there are plans for AFA to conduct around 100 audits or controls during the course of the year, so a fairly aggressive schedule of control activity is planned. In terms of the audits themselves, so companies that are subject to Sapin II, of course, are subject to potential audit. The audits can be initiated from the Prime Minister or various of the ministers, but generally speaking, at least to date, they are initiated by the AFA themselves. And the way that they work is for the AFA to issue a letter informing the company that it will be performing an audit. That letter identifies the individuals within the AFA that will be responsible for performing the audit and overseeing the audit. It is accompanied by a document request, so a request for documentation and a request for information. This questionnaire and document request covers about 11 sections that correspond to the 8 elements of the effective compliance program that was on the slide a few moments ago. And all in all, it contains about 170 questions relating to the company's compliance program. Companies are then required to provide documentation. The AFA typically comes back with some follow-up questions and then schedules an on-site portion of the review in which they meet with relevant managers, compliance professionals, legal professionals, and other individuals in roles that have relevance to compliance. All of that is taken and incorporated into a report that will contain recommendations, if there are recommendations to make, and if there is a need for the AFA to sanction companies, it can do so by issuing a warning, by requiring them to adopt different compliance mechanisms, and if necessary, by also imposing financial penalties. A few words on the extraterritorial reach of French law. So as I mentioned at the outset, one of the criticisms of the French legal framework prior to Sapin II was that it made it very difficult for prosecutors to bring cases involving corrupt acts that existed outside of France. And so without going into too much detail on the procedural mechanisms here in France, the Sapin II removed some of those procedural hurdles, one of the primary ones being a requirement that reciprocity of the offense be imposed in order for prosecutors to bring an action in France. And so the idea is that by removing some of these procedural hurdles that existed prior to the adoption of the law, it would be more efficient and more effective for French prosecutors to be able to bring actions involving French companies, French individuals, for acts that took place outside of the French territory. There is another major development from Sapin II, and that is the introduction of a new settlement mechanism called the Convention judiciaire d'intérêt public, or the CJIP. It's been compared to what are known as deferred prosecution agreements that have, or DPAs that have existed in the U.S. For a number of years, and more recently have been introduced as well in the United Kingdom. And the idea is, again, that if there is a mechanism for companies to settle corruption-related offenses, it would ultimately be to the benefit of everyone, because it will allow prosecutors to impose certain requirements on those companies, including requirements associated with the adoption of new compliance programs and requiring companies to undergo a period of monitorship. And so the CJIP is an effort of making anti-corruption enforcement, again, more efficient. It relates only to companies. There is a separate mechanism, a plea agreement mechanism for individuals, but the CJIP itself relates only to legal entities. It's limited to certain numbers of offenses, so it deals with corruption, with influence peddling, and also with certain offenses relating to tax fraud. It can be brought as long as the action publique has not been initiated, which is the formal decision by a prosecutor to charge the corporation. So it's something that is entered into prior to that decision being made. And depending on the timing of entry of the CJIP, will dictate whether companies are required or not to acknowledge certain facts and their legal significance. Essentially, if they have already been mise en examen or formally placed under investigation, they will be required to acknowledge facts and their legal significance. If not, they will not be required to do so. The CJIP can be proposed by the prosecutor, so it is something that prosecutors have discretion in order to decide whether they consider the facts to be sufficient for this type of resolution, but they're also subject to judicial scrutiny. So the decision does not rest alone with the prosecutors. If a CJIP is proposed, it is referred to the Tribunal Correctionnel for validation. There will be a public hearing, and if the judicial scrutiny is passed, then the CJIP is validated, and essentially, unless you have a situation where a company decides that it wishes to withdraw from the CJIP within 10 days, then you have the end of the prosecution. The CJIP requires certain undertakings, and again, these would be part of the negotiation and the judicial scrutiny that would be that the CJIP would be subject to. These include the payment of a public interest fine, which can reach up to 30% of the entity's average turnover for the last 3 years. It also requires indemnification of any victims, and there is the possibility that the prosecutors can require companies to implement a compliance program, which will then be subject to the supervision and monitoring of the AFA, and that can be for a period of up to 3 years. Interestingly, there have already been 3 of these that have been concluded. The first was with HSBC Private Bank. It was not for corruption-related offenses. It was for offenses relating to the laundering of proceeds of tax evasion. And HSBC ultimately resolved its CJIP with overall fines and penalties amounting to 300 million euros. There have been 2 others that have been for corruption-related offenses. One is with a company called Kiefer Warner, and the other with a company called SET Environment, both of which were accused of making payments to a procurement officer at EDF in order to be awarded contracts by that company. Those companies paid 2.7 million euros and 800,000 euros respectively in fines and penalties, and in each case were required to adopt enhanced compliance programs and also subject to a period of monitorship. And as we see in settlements in the US, in the UK, where deferred prosecution agreements have been in place for some time, the authorities appear to be looking at the level of cooperation that companies are providing in terms of resolving these types of offenses. So it will be interesting to see over the next several years how the practice of resolving these CJIPs evolves. With that, I'd like to turn it over to Charles, who will pick it up from here. Thank you.
Excellent. Thank you very much, Brian, and some very informative, useful stuff to have there. As mentioned just at the beginning, we would be happy to take any questions. So if you do have any, there is a Q&A link at the bottom of the screen. I'm more than happy to pick up any questions as we go through. As Brian touched on just a little earlier, the issue of anti-bribery and corruption from a regulatory standpoint is not new. Historically, it has been driven by the US. The Foreign Corrupt Practices Act, which was born out of Watergate, came around in 1977 and really set out the standards for trying to regulate and control bribery of foreign public officials. One thing that was mentioned that Brian touched on was that France wasn't doing enough. It was seen that France wasn't doing enough. And I think America was equally guilty of that. That for many years, the FCPA didn't really do enough. The regulation was there, but it wasn't necessarily enforced or brought in quite the same way. As history moved on, as things developed, the OECD became involved. The US became more keen to prosecute more. And there was therefore much more of a move for a global approach to combating bribery. That global approach has really helped to bring about this development and growth of regulatory regimes, which are all beginning to align much more effectively to help try and stamp out bribery in the workplace. There are obviously quite a few challenges that come about with Sapin II, but these challenges are multiple and they come from many different angles. So a company has to do lots of different things in sometimes slightly different ways to comply with many different regimes. The criteria to be covered by or to have to comply with Sapin II mean that many of these companies are also having to comply with other regulations at the same time. And usually they will come about with a series of principles or guidelines, all of which takes time and effort. Some of which is very easy to do yourself as a company, some of which requires external aids or external tools or external advisors, be they from a law firm such as Brian and his colleagues, or be they from information software providers such as LexisNexis Risk Solutions. There are some pieces which you can rely on others for, but many pieces you have to do yourself. And that cultural piece, the culture of compliance, is probably the most important to bring about. My colleagues and I will happily tell you we regularly receive communication from our leadership, from our CEO, to inform us of our culture and our commitment to that as a business. And we then take that out into the world when we're out talking to clients or out talking to the market. Other areas which need to be looked at, obviously the identification of risks within supply channels and supply chains, both from a geographic point of view, but also a functional and business process point of view. All of this and all of the need to have a compliance program in place, and Sapin II is different in that it has that affirmative obligation that you have to have it in place. To have a compliance program takes both time and resources. It can be expensive, it can be an inefficient process to bring about. And that means that there are issues that have to be looked at to try and maximize the efficiency of doing that. The cost element is two-sided in that there's the side of having to implement that obligatory compliance regime, but there's also the penalty for getting it wrong. There are all those challenges of having to have everything lined up and having to have all the processes in place, but not complying really isn't an option. And this is even more the case with Sapin II because of that affirmative obligation. It's even more the case to have to be compliant than it is with the FCPA or the UK Bribery Act. And in that particular piece, Sapin II is very much leading the way in global regulation for making it a stronger requirement. Some of the existing regulation that's out in the marketplace today has already come down very hard on French companies. We've included some examples here over the last few years. The Alstom example is one of the largest fines brought about under the FCPA, but there's also ongoing investigation and ongoing work on other areas, particularly within the UK. The UK Bribery Act may come to bear more on that, and there will be other things from other locations. The fines themselves, though, are really only a small part of the problem of getting it wrong. So when a company is charged and has a fine handed down, the headline figure is always this. So on the front page of Le Figaro, there will be this fine for Alstom. On the business pages in other newspapers, they'll be there, and it will show the fine and the value, the monetary value. There's huge knock-on effects outside the rest of the business as well, however, in terms of remediation, in terms of having to solve the problems left by the bribery and corruption case. But we've also found that there's issues of morale and employee engagement that can come about as well. It can actually have an impact on your ability as a company to attract and retain employees if you have this negative press associated with you. So the fines obviously grab the headlines, but they have the potential to go even further and cause more problems beyond those headlines. Sapin II, while the fines themselves aren't particularly huge, doesn't have that $770 million headline figure. One of the key things it does have is it strengthens and empowers France much more to fight corruption globally. It gives France a much stronger tool, a much stronger weapon in the fight against corruption. By doing so, it will also make a headline or make a case out of someone. We're still waiting to see the first really big case from the UK Bribery Act. That hasn't yet happened. We've only had some quite small fines or small penalties. The same, I think, applies to Sapin II. The penalties are in place. There's penalties for individuals, penalties for companies. But I think the biggest penalty that will come is to be the first company caught, the first company in the headlines for being in breach of Sapin II. As Brian mentioned earlier, there are the cases that have come through and have gone through the appeal process. One thing that's very different here, again with Sapin II compared to other regulatory regimes, is that control activity. So the ability of the AFA to come in and control, to audit, and to actually proactively look at a compliance program. Now, in other compliance regimes, the UK Bribery Act, for example, it's only after the event that a regulator or an enforcer will come and look at your compliance program. With Sapin II, there is a proactive agency monitoring those compliance programs. That should mean that A, companies have better compliance programs in place, but it may also mean, B, that the AFA and the agencies are able to see and identify problems more quickly and more effectively and bring those out into the open. That can only be a good thing. So again, the desire, I think Brian said, was desire to be a leader in corruption from the AFA. That desire combined with the ability to control and audit is going to make Sapin II very, very strong in the marketplace. Sapin II itself is a big push forward. It's a very, very strong move by France. And as I mentioned at the beginning, it brings France very much in line with the global efforts to combat corruption. It's very strong in its guidance. It's very clear in pointing out what a company needs to do to be compliant. There has been criticism of the FCPA in the past. Some of the guidance isn't quite as prescriptive or direct as would be liked. That same criticism has been put on the UK Bribery Act, that the 6 principles and the guidelines aren't as detailed or as accurate as some people would like. Sapin II has taken that on board and has provided much stronger, much clearer approach to how to have that effective compliance program. Within that, as Brian said, and we talked about the Agence Française Anti-bribery, the AFA, that I think is probably one of the strongest pieces within Sapin II. That ability to look at a company's process, to audit, but to not just be a passive reactionary regulator, but to be a proactive, active regulator, looking at and monitoring and really advising and pushing it forward. I would hope that this is something that other regulatory regimes take on board, because it appears to be one of the most positive aspects of Sapin II, that ability to really focus on it in that respect. Brian had a very similar slide looking at the links between. So we put it onto a blank slide for some reason. I'm not sure if anyone can see. Bear with me 1 second. Technology is always having my problem there. Sorry, unfortunately it appears that the blank slide isn't actually working on the animation, which is slightly frustrating. There we go, it is. The FCPA, I wanted to take a little time to look at 3 pieces of regulation, really to look at how companies who have to comply with multiple regimes can effectively do so. Because there are similarities, there are obviously differences, but there are similarities. The FCPA is put in front as the original, the father of all anti-corruption regulation, and rightly so. It's the oldest, it's the strongest, and it's also the one that's brought about the most penalties and the most fines. It does have some very specific nuances, such as it only covers the payment of a bribe. It also only really focuses on the foreign public official offence and the instrumentality of state. So it's very much focused on government ownership, government control, and political positions or persons of political influence. It also has the interesting, some may say, grey area of facilitation payments, where these are permitted under the FCPA. But crucially, it makes the point that companies have to have a strong due diligence program. They have to have a very strong process of audit and control to have all the communication, documentation, the books and records piece. And there's also an absolute commitment to training and communication within the business. The UK Bribery Act takes things a little bit further in that it covers both paying and receiving a bribe, and it makes no distinction between state and private. So it's a much broader application of what bribery is. It prosecutes the bribe recipient as well as the bribe payer. Now this hopefully should level out the playing field even further, particularly if companies are complying with both. The 6 principles that the UK Bribery Act puts in place really helps cement what a company has to do to comply. Now, unlike Sapin II, there isn't that obligatory requirement, that affirmative obligation to have a compliance program. But if you are working within the 6 principles, you're able to have that defense of we did not fail to prevent bribery. Along with the FCPA, due diligence is a key. Risk assessment, of which due diligence is a key part, is another of the principles. The ongoing monitoring, review, and checking of the process is there. The training communication piece is a commonality across the board. There's also proportionality, which I think is a very valuable lesson from UK Bribery Act. the ability to make sure everything is in line with the risks that you face. So you don't have to spend money, you don't have to do too much, you have to do enough to make sure you're proportional to your risks. And also includes that failure to prevent. In France, obviously under Sapin II, there is also the French Criminal Code, as we touched on, I think, at the beginning, that makes that link between paying and state and private. Under the requirement to have that compliance program to make sure you have that. In the US it helps, in the UK it's an affirmative defence, in France it is an absolute obligation. There is also the element of carrying out due diligence onto third parties, supply chains, etc. There's the requirement to have accurate, complete documentation, so books and records. There's a requirement to have the training and communication in place, that commitment from senior management. The mandatory policy of having a compliance program, I think, could be argued as being a failure to prevent offence. So it's there, it's just even stronger. That's a very powerful message to have. The real common ground, therefore, is that there is an absolute commonality across the board that companies have to train their staff, communicate to their staff, and above all have absolute commitment to eradicating bribery and corruption from their business. So this trickles down from the OECD requirements, it trickles down through government regulations, it trickles down through Sapin II, it trickles down through the AFA into a company itself having that commitment to work against bribery and corruption to combat that. There's then the requirement across the board to have adequate due diligence, to carry out that due diligence, to identify where there are potential areas of risk within your business, be that within your own circle, with your employees, with your workforce, or within the wider third-party risk area of suppliers, agents, joint venture partners. Now, obviously, if you're a French company with that requirement of having the 500 employees, etc., in France, that means you are French. However, it's the sales element, the revenue element, means that many of these companies are going to be relying on overseas third parties for supplying of raw materials or for distributing goods for sales channels. So that extraterritoriality piece means that in many cases companies will have to comply with more than one regulation. Finding that commonality really helps to make it more effective. Ultimately, there are certain baseline practices that have to be put in place. The three key ones really, that training and communication, the due diligence and risk assessment, and the adequate audit trail, the books and records and accounting detail, are applicable across the board. And while here I've picked deliberately on the US, the UK, and Sapin II, I'm in the process of writing a presentation for a piece in Mexico, and it would be equally applicable in Mexico. I'm speaking soon to the real estate market in Australia. It would be applicable in Australia. These baseline practices mean that a company is able to apply strong compliance processes across multiple jurisdictions, answering many of the risk areas in one time. There is, however, a real advantage to this. It's often the case that compliance is viewed as a negative. I once heard someone describe compliance as the department of no, which seemed a little bit harsh, but compliance is often seen as getting in the way of doing business, slowing down business, stopping things. And there's a wonderful quote, it's translated to Latin from a 10th century Arabic text, that knowledge is power, scientia potentia est. Well, knowledge is power. And through doing all of the due diligence, all of the books and records, and all of the communication and training, you have the opportunity as a business to gather really strong information, both on your internal practices, but also crucially on your third-party relationships. That knowledge can be translated into power. It can be used to help engender better relationships with third parties. The more you know about someone, the more you're able to actually engage with them effectively. And it can also be used to help have better relationships with your suppliers, both in terms of the services they provide, but also potentially in terms of the price. Quite often the due diligence process is siloed away, is conducted, and then it's delivered as a yes or no answer to the business. And at LexisNexis Risk Solutions, we're seeing increasingly companies wanting to use that knowledge as a powerful tool within their business. So they're able to take the information from their due diligence program and trickle it down to the business, to the end users, to help develop better relationships. By making a compliance program with those baseline approaches of due diligence across the board, companies are also able to minimize the processes. We're seeing a lot of people combining their supply chain onboarding risk due diligence with their compliance-led due diligence. And that can only be a good thing because you're having fewer processes, so you're getting stronger results from those processes, but crucially, you're not overspending on a compliance program, or you're not under-complying. It's able to actually focus efforts and focus resources more effectively onto the middle ground of finding information. That then can lead to better sharing of information, which again can help lead to that increased information, increased knowledge, increased power within the supply chain. Compliance overall, though, is a prevention. It's an insurance policy. It doesn't cure everything. It doesn't stop corruption from happening. There's been a few cases. I think there was certainly one of JP Morgan, I think it was in China, who had an issue of bribery, were able to identify it, explained that they'd had all of their compliance programs in place, but then were able to show that it was an individual action. It wasn't the company failing. That helped protect their reputation. When a company is dragged through the press, is dragged through the media for being in breach of something, that can really hit their reputation. It can hit many other things as well. The company itself can be hit by breach. There was the famous Siemens case under the FCPA, where in the weeks following the actual fine being handed down, the company's share price halved in a matter of weeks, and that's a very big issue. We're now seeing an increased look at enforcing against individuals, and that enforcing or charging individuals with this will have a real impact on employee and company morale overall. So while the share price is one thing, the fines are one thing, the people who have a stake within your business, if they are committed to stamping out bribery and corruption, they will care and they will find it really matters. In summary, I just wanted to touch on a couple of little pieces, if I may. I'm just, again, slightly losing the slides here, which may take a little while. I'll just wait for that to pop up, hopefully, as we come through. One of the key things about compliance with multi-jurisdiction regimes is that one size doesn't fit all. It isn't the case that you're able to actually have one compliance program to work for everything. It doesn't fit perfectly, but you are able to take some of the elements you do for your Sapin II compliance and help provide a compliance defence for the UK Bribery Act, for example. It does mean there has to be a baseline of efforts, an absolute underlying core minimum of what you do, but that baseline of due diligence and risk assessment can really help to focus your efforts, your resources, and ultimately your compliance spend as a budget on where it really needs to be. So by balancing all the requirements from different regimes, you're able to focus more effectively. As such, that broad approach may only seem to be an expensive option. It's dreadful to talk about cost, but it may be seen to be inexpensive. It isn't really, because you're able to take a compliance program, and in particular the third-party due diligence piece, and really turn it to an advantage by sharing that information and sharing what you're looking at. Compliance can be a benefit to a business. For too long it's been seen as a negative. So not only can it be seen as a benefit to a business in the sharing of information and working on what you have, it obviously also helps communities, it helps countries to benefit from cleaner, more ethical businesses, and that must be a good thing. Sapin II, as a piece of regulation, really marks another step in, I think, what can be called the race for the top. That race for the top in terms of being the highest common denominator in anti-bribery and corruption. Certain key elements, that affirmative obligation to have a compliance program, and the proactive control activity of AFA, combined with the other elements that Sapin II has in common with the UK Bribery Act and the FCPA, really mean that we're getting into a much stronger, I'm not going to say a golden age yet, but a much stronger age of anti-bribery and corruption worldwide. Hopefully, we won't see, oddly, hopefully we won't see big enforcement from Sapin II, and we will see the control measures really having a strong impact. But we do want to make sure that everyone is aware that all of these compliance obligations are really going to help bring down corruption globally. So there's a very positive, strong message to come at the end. All of this will hopefully help fight corruption together. So thank you very much. I'll hand back to Kader if there are any questions.
Thanks, Charles. Fantastic. Yeah, we have a few moments to take questions. So if you would like to ask a question, please click on the Q&A icon at the bottom of the screen and type it into the question box. Yeah, I think that's really informative. I think, Charles, you definitely answered the main question that I had during that presentation, which is how much is what we're speaking about today, do you feel is echoing what we're hearing in terms of the global trends? And it definitely seems like everything's moving in the same direction.
Yeah, I think that's the case. And one of the interesting things here is we have myself in the UK, Brian, you might be able to tell by his accent, I'm not originally from France. We then have a real worldwide group of people, both from the supply side, from lawyers and from LexisNexis Risk Solutions, but also in companies really committed to helping stop bribery and corruption. I think it's quite a nice thing to be able to say that we do when people ask that classic question, and what do you do at work? It's quite nice to have a very positive, kind of strong global commitment around the place.
Absolutely. Okay, I think we're coming to the end of our time now. So, Kader, do you have any closing comments?
Well, maybe I can thank you again, Brian and Charlie, for all the insights that they shared with us today, and we understand the importance to how to build a strong baseline due diligence program within an organization to comply with the Loi Sapin II. It was also very interesting to understand the similarities between the different compliance regime across the globe. So very informative. So again, thank you very much. Thank you very much for all the attendees of this webinar. If you have any questions or if you want to continue the discussions, feel free to reach out to me directly.
Thank you.
Thank you.